what happened was that the Supreme Court only eliminated Article 3 of DOMA, which was the one defining spouse and marriage, and it removed the bar on the federal recognition of marriage. And what that means is that if the federal government doesn't have a definition of marriage, traditionally the definition of marriage was reserved for the states. So what that resulted in is a system that we have now where every state gets to define what it recognizes as marriage, and the federal government will defer to that definition. So interestingly, each state will dictate how you are treated from a marital standpoint and from a taxation standpoint from a federal government level. And as I mentioned, DOMA did not, or the Windsor decision did not quite go as far as many might have hoped. Specifically, Article 2 was reserved. And what that means is that while some states can choose to recognize marriages, other states can still prohibit marriages. And those states are not required to recognize marriages entered into validly in another jurisdiction. So, for instance, my state of Illinois or my former state of Kentucky can choose to ignore marriages validly performed in New York from a state law and state tax standpoint and retain their own definition of what constitutes a spouse. So that Article 2, that full faith and credit clause, was not struck down. DOMA also didn't create a federal definition of marriage. It just removed the federal definition of marriage and instead deferred to the states on how a marriage is defined. The final thing the Windsor decision did not do was require any kind of recognition for something less than marriage. So many states, like Illinois for instance, didn't have the political capital to implement same-sex marriages, and as a result they went for something less, like a civil union. And while the DOMA decision, or the Windsor decision, struck down DOMA and allowed the federal government to defer to states and treat valid marriages performed in the state as valid marriages for federal tax purposes, it did not require and actually does not permit the same treatment for civil union partnerships or domestic partnerships, et cetera, et cetera, et cetera. So a little bit more limited there. But as the argument goes now that same-sex marriages are permitted, even though not every state permits it, you could go get married somewhere and you wouldn't have to rely on that domestic partnership. Okay, so here's the land. So that makes every state's decision on same-sex marriages more significant, but it also creates as an administratively complex web for plan administrators who are attempting to determine what to do from a plan administration, from a plan tax standpoint, because now marriage is dictated by the states, and as a result, you've got potentially 50 different definitions of marriage, and what might be a marriage in one state would not be a marriage in other states. So, pre and post Windsor, and this is kind of the breakdown we're going to take for the rest of the presentation, to sort of highlight how your benefit plan administration is changing over time. The laws still govern, the laws governing same-sex spouse benefits or defining spouse remain the same. But the reality is ERISA, the Internal Revenue Code, COBRA, except USERRA, FMLA, these are all federal laws that for purposes of defining spouse relied on the federal definition of spouse, which excluded coverage for, or, treatment of a spouse for a same-sex union. Now, so the significance here is that when DOMA got struck down, that change to the definition of spouse at a federal level flowed through to the rest of these laws, ERISA, federal, Internal Revenue Code, COBRA, et cetera, et cetera. So while there previously was a locked-in federal definition for spouse, and a lot of people define their spouses under the plan as defined under DOMA, that's no longer present. So you've got a bit more flexibility in your benefit plans in terms of how you define spouse going forward. So this was the big question following Windsor, but it has since been answered, and it was really the question of, will the IRS in its treatment of spouses go with the state of ceremony rule, the state of residence rule? And spoiler alert, they went with the state of ceremony. And what that means is that from a federal tax perspective, the IRS decided that it would recognize a marriage as a valid marriage for federal tax purposes if it was entered into in a state that recognized same-sex marriages regardless of where the individual resides now. Obviously, the significance of that is that once you get married, you're not stuck in that state where you got married for purposes of preserving your federal tax treatment of your benefits. No matter where you move, if you were married in a state that recognizes same-sex marriages, or in a foreign country for that matter that recognizes same-sex marriages, that status carries with you. Now, that's from a federal perspective. Remember, Article 2 of DOMA still exists, meaning that from a state perspective, state tax laws don't need to recognize marriages performed in other jurisdictions. They can still choose to exclude those marriages or exclude favorable tax treatment for those marriages.